Welcome to Navigating Receiverships, a podcast from the Commercial Receivers Association, focused on building a better understanding of what brings companies into receivership, what happens in receivership, what makes them unique, some alternatives to receiverships, and ultimately, what happens to the business as the receivership is closed out. I'm one of your hosts, Eric Morcheski, CRA board member and CEO of Nimble Strategies. Welcome, everyone. We're here today with Greg Milligan of Harney Partners. So excited to have Greg join us. If you don't know, Greg is our Texas State Director for the Commercial Receivers Association, in addition to all the other work he's doing with so many intriguing cases across the country and maybe even around the world. Greg would be able to answer that better. Greg, thanks for joining us. Will you tell us a little bit about yourself and about Harney Partners?
Sure, Eric, I appreciate the opportunity. I also want to take a chance to say that I'm really impressed with what you guys have grown with the Commercial Receivers Association. I think it's serving a really unique niche in the market, and I'm happy to be a part of it. So, yeah, I mean, as a broader statement, Harney Partners is a boutique consulting firm that does turnaround and consulting work all across the country. We're centrally located, mainly Chicago and the Texas market, kind of intentionally being in the central time zone. I did an analysis at one point, and out of our last 100 deals, we'd had some nexus in 42 states. So being able to equally fly, left and right has been beneficial to us. About 25 folks, turnaround and restructuring, referred in by banks, referred in by insolvency counsel is a large part of our practice. And then the other part of that practice is our fiduciary services, which obviously include receiverships.
That's great. Yeah. So, you and I were talking a little bit ago. Nobody grows up saying, when I grow up, I want to be a receiver. How did you get into this work?
Yeah, it's funny. At career day, that was never an option. However, as a quick aside, at my son's elementary school a couple of years ago, they asked 4 or 5 parents to come talk about their jobs. And I would have to say, in hindsight, if it wasn't for my son recruiting people, I don't know that I would have had anybody at my talk, because I was up against a former news anchor who wrote a book during COVID called The Poop Diaries. There was a former Navy pilot, and there was actually a stuntman who was actually sporting the gnarliest black eye from a recent incident. So I didn't stand a chance against
And
those
they didn't
guys.
think Greg Milligan is who I got to go see?
Yeah, turnaround consultant, the receiver was not high on, fourth grade boys or girls' interests. So, but in reality, when I was in college trying to earn a little extra money, I worked in the mailroom for a couple of Chapter 7 trustees here in Austin. And then when I graduated, didn't want to leave Austin. So went to work for them full time and just help them administer cases, draft pleadings, work on sales and liquidations. And then in 1998, I met Jim Harney, who's the founder of Harney Partners. Went to work with them and did all kinds of turnaround and restructuring work all over the country as an FA, not as a fiduciary. Still lived in Austin, but got on a plane every Monday, came back on Thursday evenings, mostly working out of the Chicago office until I was able to build my own book of business here in Austin. But I've always had a real interest and passion for more of the fiduciary work, because I think it's the most interesting combination of skill sets. You have all the technical aspects from the accounting and the finance. You get to play pseudo lawyer with all the legal considerations, and then you get to have some really cool negotiations and M&A transactions or other deal making component that I think is really interesting.
Yeah, no day is ever the same, right?
Yeah, if I had to sit at the same desk and do the same thing every day, I would go nuts. And
Yeah,
this is definitely not that.
Me too. So yeah, so we're here today. We're going to talk about one of your receiverships in a pretty unique industry, I would assume, in a quarry. So dive in a little bit here. Tell us a little bit about what was going on in the industry. What were some of the problems that this company was experiencing that brought this into a receivership?
Yeah, let's kind of set up the landscape a little bit. The receivership entities were 5 affiliated companies. One was the holdco. One owned a 360-acre gravel quarry west of San Antonio. One was the public-facing company that operated the gravel quarry. One owned the quarry operating equipment, heavy equipment, rolling stock. And then one that was actually the most profitable owned and operated a residential concrete foundation company in the San Antonio and Austin markets. They had contracts with a couple of the largest volume home builders. So that ownership structure was set up 50-50 between 2 different families. one family, the plaintiffs, put in all the money, put up both cash and lines of credit to get the business started. The husband was in the construction and real estate development business, and the wife was a C-suite executive at one of the largest insurance companies in the U.S. So very sophisticated people. The other family, the defendants, had experience in the concrete business and aggregate hauling business, and they were kind of the sweat equity in the deal. Somehow the husbands knew each other, but not very well, and the defendants approached the plaintiffs with the opportunity to, after they identified the quarry site and wanted to try to exploit those resources. So the defendant wife had inherited a significant ranch property just west of San Antonio when her father passed away. And the quarry was ultimately part of that site, which went into the joint venture. So the joint venture property was contiguous to the defendant wife's family estate that she controlled through a related entity. So in the transaction, the receivership entity bought the quarry land and also assumed the first lien on that property. Again, it was about 360 acres. We had a reserve report completed, and it had about 8 million tons of aggregate on the site. So significant holdings and values.
Yeah. So starting into the receivership side of this, what entity or entities were actually put into receivership? Was it the holding company? Was it pieces of this, or were you kind of having to find your way around and navigate through this all with only parts of it in the receivership?
All 5 of those initial joint venture entities were put in to the receivership. One entity that we'll get to in a minute wasn't in the receivership, and that's kind of where we had issues. But the case was initially filed in the fall of 2021, and then they sought a receiver in March of 22 the following year. The court ordered the appointment of a receiver in March. And then it was probably 6 weeks later when the order actually got entered. And I think we had to go back to the court once or twice more to get her to rule on the actual language in the order, because the defendants were very difficult to negotiate agreed language with. So the genesis of the case is that the plaintiffs discovered in 2021 that at least for a year, the defendants, again, the sweat equity partners, and the plaintiffs weren't involved in the operations, had misappropriated the concrete construction company, took all of its equipment, its employees, its customers, and put them into a separate wholly owned entity of the defendants that they used previously when they were in that same business. And I'm sure listeners to your podcast will recall that new housing starts were increasing a lot during 20 and 21. And 2021 is kind of when they discovered, the shenanigans that were going on. But for that 2-year period, for a 2-year period between August of 2020 and August of 2022, the concrete company had total revenues above $100 million. So we're talking, real dollars in controversy. So they also discovered that after the lawsuit was filed, that the defendants had used the diverted proceeds from the concrete business to buy the note on the quarry from the lender in an affiliate's name. So it was, from the plaintiff's viewpoint, you stole our money, then you bought the note over our quarry land, and now you're trying to exert 2 levels of control, not only as a co-owner, but as the lien holder. So
let's see what the problem is here.
Yeah, well, it's not an uncommon situation where the money partners put their money in and the sweat equity guys take liberties. But
Yeah.
so in addition to that, our analysis also suggested that the defendants, either directly or indirectly through other entities, pulled out about an extra $7 million in cash from the concrete company for their personal benefit through inflated salaries or dividends, insider rents, payment of personal expenses like an African safari or and other travel or private school tuition for their kids and medical expenses. This is the non-receivership entity that I'm talking about, because they took the receivership assets and put them into their wholly owned entity. Mm-hmm. And I didn't have any control, visibility into that except for what I got through discovery. But literally the week that I was appointed, the defendant wife immediately doubled, tripled, and then quadrupled her salary within a month to pay herself at a rate of $1 million a year out of the non-receivership entity. So yeah, they were pretty brazen about it. We got them to dial that back to something more realistic, but they took several liberties when it was available.
Well, and I think, something to keep in mind if you're listening to this and to kind of apply industry based, this is not a high margin industry. I actually had a receivership at this same time in the concrete industry. Now, they didn't have the full verticality of your group, but, you know, they're talking net margins of 1% oftentimes when they're building highways and pouring concrete. But you have to do a lot of work to get that $1 million out from that salary that you were just talking about if you're going to only have a net margin of 1% on revenues. And so just something to kind of keep in mind when someone's looking through all these things as a receivership. Now, obviously, with them being vertically integrated as much as they were, they probably had better margins than that, but still.
They did. They were closer to 10%, I think. But another of the allegations, and I think there was evidence to support it, is on the quarry side, they were selling aggregate to the defendant's wholly owned business for less than cost. So they were, they were double dipping. I mean, it was hurting the joint venture entity, but they were more profitable in the business that they misappropriated, by getting their raw materials cheaper. So they were winning both ways.
So you've rolled into receivership now. What happened when you got into the receivership? What did you see, that made it different? What were some of the outcomes that you kind of went through with it? How did it go?
Yeah, so the receivership got off to a really unusual and frankly tragic start. I mean, only 3 days after my appointment, the defendant husband, who was the driving force behind the formation of the joint venture and handled all the operations, passed away suddenly. He was had an ongoing illness of some nature, was seeking treatment in Florida, and suddenly died during that trip. So, in addition to the personal toll that the death took, as to the receivership, it removed a key fact witness to the litigation and placed the management of both the concrete company and the ongoing litigation into the lap of the widow. So that created challenges because she wasn't versed, in the day-to-day operations of the company. It also created some unique legal issues where the district court overseeing the receivership intersects and frankly often conflicted with the probate court. So that conflict significantly slowed the progress of the case and allowed the defendants to use some procedural mechanisms to slow the case down a good deal. So, but once we finally took over the real property and personal property related to the quarry assets, about 6 weeks or so, it was clear that they just weren't going to be able to be profitable. There wasn't a turnaround that was available to us. So we shuttered those operations, sold off all the heavy equipment and rolling stock to pay all the secured debt and returned a surplus to the estate. But again, those assets isn't what was going to make or break the case. The real value of the estate were the litigation claims against the defendants for misappropriating the concrete business.
Yeah, you got to sell a lot of dump trucks to get to that $7 million you talked about earlier.
Right. No, exactly. And that's just what they took out in addition to what the 50-50 split should have been, on the concrete company profits. So then as we're going through the receivership and we're preparing to sell the quarry, which at that point is largely just based on the reserves report because, they had proven that it wasn't operating profitably, we became aware of an access issue with the quarry. One of the receivership entities, I think it was the public facing quarry sales operation, which is again owned 50-50 by both parties, paid for the construction of a newly improved road that went from the highway to the quarry site, probably a couple miles in total. And that road was built over land that was inherited by the defendant wife, but wasn't part of the joint venture ownership. So in return for building that road, the defendant wife was supposed to give us a permanent easement for the benefit of the quarry and the joint venture entity. But as we got into our pre-sale diligence and engaged lawyers, we were able to determine that there was never an easement recorded. So the benefit of the new road went to the defendant wife's family ranch and not the receivership entity. But more importantly, the quarry didn't have any improved access. So obviously that devalued the property. So there was another easement that ran with the land from a prior purchase, but that easement wasn't improved at all. It was literally still a cow pasture. And what easement rights we did have had some pretty tight turns for those large gravel trucks that would have been problematic. And the access to the highway, the actual curb cut on the highway was inferior to the other one. So another way that the plaintiffs were kind of disadvantaged throughout the transaction.
So what did you do with all this? You've obviously dug into all this information now when you're in the receivership and found the issues. You're starting to go through, you talked a little bit about your pre-sale diligence. How do you turn to cite back to that book that was written that strayed listeners to your talk at your kid's school? How did you take the poop diaries and turn that into a successful receivership?
Yeah, I mean, obviously the Quarry site, I mean, and we marketed it for sale and we had some interest, but the buyer, who was a large industry player, a national player, ultimately was challenged by the access, the acrimony between the parties, and the fact that the defendants who were acrimonious to the transaction were the contiguous landowners. And so they didn't want to buy into a neighbor fight, for the rest of their holding of that property. So while we had great litigation claims against the defendants and I think a really solid damage model, collectability was the issue. The defendant's husband's probate estate didn't show any meaningful assets, and the defendant wife had what we believed to be significant wealth, and I think admitted to be significant wealth, but those were all in remote trust and other entities that were outside our reach. So we ended up reaching a settlement with the defendants to resolve the direct claims, because as receiver, I held the entity's direct claims for what I thought was a reasonable value given the impediments to collection. That settlement would have mooted the plaintiff's derivative claims, but the plaintiff's derivative claims, but the plaintiff still had their direct fraud claims against the defendants. So we filed that settlement motion, basically a 9019 motion that you would call it in bankruptcy court. And the plaintiffs were a little exercised. They didn't like the deal. They thought it was too cheap. So we mediated that dispute, which was actually the second mediation during the receivership phase of the litigation and the fourth mediation overall during that case, because two of them happened before I was appointed. So at the end of the day, about 14 months into the case, we mediated a deal where the defendant wife would get all of the plaintiff's interest in each of the receivership entities for cash. Again, she was putting in cash that we couldn't otherwise reach unless she voluntarily put it into the deal. And in reality, the only thing of value at that point was the entity that owned the quarry. The other ones had all been stripped of their assets and were basically shells at that point. But for corporate hygiene, they wanted to buy everything. So with the settlement, it was also important to the defendant wife that she could kind of reassemble her family holdings and retain the option of restarting the quarry operations or making sure that nobody ever quarried that land again. And having that control, since it was basically the front door or next door neighbor to your family legacy ranch, you don't want somebody else coming in there and strip mining it, and leaving it, in disrepair. So, but it was interesting. I'm sure you and other listeners have had the same situation where a plaintiff brings you into a case and touts you as the savior. You're going to make everything all better. And then you take a position they don't like, and all of a sudden you're the worst guy in the world. And so we had to go through that here, but ultimately, found a resolution. And I mean, I get it. I mean, I understand their frustration. They were totally deceived. And at the end of the day, the economics weren't wholly equalized with the settlement. I mean, they didn't get back every dollar they should have been entitled to. But again, based on the recoveries that were available, it was the best outcome. So even though the emotional toll it took on the plaintiffs, they paid their lawyers millions of dollars in attorney's fees, they still made a good profit on their initial investment. It's just not what it would have been, absent the fraud that the defendants perpetrated upon them.
Yeah, so you walked through all this, you've reached a closeout, obviously. What did you take away from it? What were some of the lessons learned that you or that some of our listeners could take away from this experience?
I think it reinforces a couple of things. I was talking to a bankruptcy lawyer in New Orleans yesterday, and I kind of stole his thunder. But part of our job, and sometimes a large part, is being a therapist, right? It's dealing with the emotional part of this. So I guess when we're listing the technical, the legal, the transactional skill set, part of it is you got to have some EQ to be able to manage difficult parties in what's probably the most stressful situation in their life. But more specifically on this one, I had a better appreciation for the possible role of receivers serving as kind of a de facto mediator to help the parties find a path to yes. In this case, I did two mediations that not only helped me kind of grow my skills in that area, but focus on the components of the receiver position, being able to play that role of a mediator or consensus builder. That's not applicable or possible in every case, but it can be a powerful and productive tool in many cases. So,
Yeah,
but
especially in partnership disputes. I would assume that's it. It comes up a lot more frequently than, if a bank has brought you in just because of lack of payment or whatever the other issues might be that brought the bank to bring the case forward. But when you start talking partnership disputes, that mediation side, I think, comes out more and more.
yep, and those corporate divorces are becoming a mainstay in our practice right now. People have realized that receivership can be an effective tool to get those resolved. So, our case, the last two mediations we had was with a retired bankruptcy judge in San Antonio. And he and I just kind of teamed up. I mean, we were both basically, the de facto mediators, but as a receiver, you've got a much greater ability to reach a resolution because you're also a party litigant to the mediation. We control litigation claims and other assets of the estate that we can leverage either as a sword or a shield to help get parties to understand and see potential solutions. And I guess the sword part of that is, especially when those proposed solutions are demonstrably better than other adversarial outcomes, right? Because you can do some bad things to them and cause them some issues if they're not being realistic and being trying to be part of the solution as opposed to just a problem. So again, talking about my kind of evolution of understanding this mediation component a little more fully. In bankruptcy court, I think we're all familiar with the concept of a court-appointed examiner. And sometimes those examiners can have expanded powers where they can exert some management control. So I've started using the term mediator with expanded powers to kind of help better describe the unique position that a receiver can play to help find, an equitable solution and hopefully less expensive resolution, to what are often very, very messy situations.
Yeah, I mean, I think we're all seeing bankruptcy like a Chapter 11 becoming more and more expensive and taking longer and longer in many cases. And so, when you look at receivership or an ABC or some of the other options out there, some of the alternatives to bankruptcy, depending on the case, right? Because obviously there are some cases that it still just makes more sense to go the bankruptcy route. But depending on the case, it can really make a lot of sense for someone to utilize receivership or a mediator with expanded powers. Um, and
Yeah,
really,
well, I think it's also analogous. If you serve as a Chapter 11 trustee, it's very similar. You've kind of got the same powers and abilities to, try to cajole folks into more moderate positions that really make sense at the end of the day, as opposed to just going scorched earth and not really focusing on the practicalities of the situation.
yeah. Well, thank you so much for doing this. Is there anything you want to leave listeners with as a takeaway from here, or anything else?
No, I appreciate the opportunity. I think these podcasts are great. I think it helps me as a member and a listener of this series to basically get the Cliff Notes version, and I get to learn from other professionals in our industry without having to make that mistake or actually go through that particular situation. So I appreciate the opportunity to participate and the opportunity to be able to listen to your series as you can continue to roll out new podcasts.
Yeah, as one of the hosts, I enjoy listening to everyone's stories because I do think I don't know if it's misery loves company or if it's what that effect might be, but it's great listening to everyone, learning from experienced professionals like yourself and so many of our other members. So again, thank you so much for doing this. You can reach Greg. He's part of Harney Partners, great organization, very active with the Commercial Receivers Association. And so Greg and all of his partners, I know, would be welcome to any outreach that you might have. Thank you. Thank you for joining Navigating Receiverships, brought to you by the Commercial Receivers Association. Find more information at commercialreceiver.org and catch every Navigating Receiverships podcast by subscribing through your favorite platform today.